Let's read some of this Sotomayor dissent. So you have Trump v. Casa, v. Casa, v. Casa, mi casa, su casa, right? So this court case just came down, and this is saying that permanent injunctions aren't allowed, but this has to do with the birthright citizenship case, but they're not going to talk about the merits. They're going to say that there is some procedural problems, and the procedural problems is when district court gets somebody that comes in, they arrested them, they were an American. We've already deported 10 kids that were born in America that I know of, at least. So if you're born in America, that's what makes you an American. That's the only thing that makes you an American. You didn't have to pass a test. You didn't have to dunk a basketball. You didn't have to turn 18 and, pass a civil exam, a civil. So there's nothing that you actually had to do. Immigrants have a lot higher threshold in order to become a citizen. But if you're born here, according to the 14th Amendment, you're an American. Well, this doesn't rule on the merits. This just says that permanent injunctions, district court, if they have a case where they have somebody coming in and they arrest them and they're born here, and then they're saying, well, that means they're a citizen. Well, the judge might issue a permanent injunction for any citizens. Note, Trump administration, you cannot arrest citizens of this country. If you were born in this country, then you are a citizen. So they call them anchor babies, but I think that's where the rubber meets the road. That's where you draw the line in the sand. And as sad as it is, if it comes down to what's legal and what's not legal, you would deport the parents who are illegal, who are not here, undocumented or whatever. But the child who was born here, that's, a person. That's a human. That's an American. That's an American citizen with all the privileges and immunities as the rest of us. So let's just read some of Sotomayor's dissent. Children born in the United States and subject to its laws are United States citizens. That's been the legal rule since the founding of America, and it was the English rule well before then. This court once attempted to repudiate it, holding in Dred Scott v. Sanford, 1857, that the children of enslaved black Americans were not citizens. The big thing with Dred Scott, that's one of the reasons for the Civil War. And one of the reasons for the Civil War was the awful, terrible Dred Scott decision. How many other decisions were there? You had Plessy versus Ferguson, right? Dred Scott decision. There's been a lot of terrible decisions. To remedy this grievous error, the states passed in 1866 and Congress ratified in 1868 the 14th Amendment Citizenship Clause, with which enshrined birthright citizenship in the Constitution. There it has remained, accepted and respected by Congress, by the executive, and by this court until today. It is now the president who attempts in an executive order to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional, and for that reason has enjoined the federal government from enforcing it. Undeterred, the government now asks this court to grant emergency relief, insisting it will suffer irreparable harm unless it can deprive at least some children born in the United States of citizenship. The government does not ask for complete stays of the injunctions, as it ordinarily does before the court. Why? Well, the answer is obvious. To get such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, and this court's precedents, federal law, and executive branch practice. So the government instead tries its hand at a different game. It asks this court to hold that no matter how illegal a law or policy, courts can never simply tell the executive to stop enforcing it against anyone. Instead, the government says it should be able to apply the citizenship order, whose legality it does not defend, to everyone except the plaintiffs who filed this lawsuit. So instead of just saying that this executive order, which, kills birthright citizenship, they're saying that if somebody goes to court and they, question the arrest, only that person who takes it to court is going to get the protection. Instead of doing a permanent injunction and, saving everybody against this illegal order, it's clearly illegal. Everybody knows it's illegal. The 14th Amendment is part of the Constitution. 14th Amendment says if you're born in America, you're a citizen. The gamemanship in this request is apparent, and the government makes no attempt to hide it, yet shamefully this court plays along. A majority of this court decides these applications of all cases provide the appropriate occasion occasion to resolve the question of universal injunctions and end the centuries-old practice once and for all. In its rush to do so, the court disregards basic principles of equity as well as the long history of injunctive relief granted to non-parties. No right is safe in the new legal regime the court creates. Today the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. So that's the problem right there, right? So anybody who's a law-abiding American that's saying it's okay to break the Constitution, then you're saying it's okay to break the Constitution when it comes to the Second Amendment. When you have, somebody who's against the Second Amendment becomes president and they issue an executive order to round up all the damn guns, well, you can't have a permanent injunction. The only way that you'll be able to fight the gun confiscation is if you personally file a lawsuit in federal court. If you personally don't file a lawsuit in federal court, they can't do this nationwide injunction. So no more nationwide injunctions. The majority holds that absent cumbersome class action litigation, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the formal parties complete relief. That holding renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit. So you would like to think that maybe some people might fight the Second Amendment gun confiscation, and then when they beat it, then that means the rest of us gets to keep our, firearms. But they're saying no. If you have 20 people and they all got their guns taken away, and one person files to fight it, only that one person that filed a federal lawsuit, who got a damn lawyer, paid him whatever, $20,000, $50,000, $100,000 to fight the case, only he gets to keep his guns. Nobody else gets to keep their guns. So you should be very worried. And when we're breaking the Constitution, don't think we're only breaking the Constitution for, brown-skinned people that are undocumented. People that are born in America are Americans. So this could be used against anybody. And then when they deport people, they're not just deporting them back to their country of origin. Sometimes they're just sending them to Sudan. Sometimes they're just sending them to a country that just houses prisoners. So that means whether or not, if you come to America, if you were born in this country, say you were born in Illinois, and then somebody said that you were illegal, you don't have your documents, and then they send you to Sudan. Why? Because, the 14th Amendment doesn't matter. You couldn't prove that you were a citizen, and fuck you. Who gives a shit? You're not an American, and you don't have any American freedoms and American rights. So I will not be complicit in so grave an attack on our system of law. I dissent. The majority ignores entirely whether the president's executive order is constitutional, instead focusing only on the question whether federal courts have the equitable authority to issue universal injunctions. Yet the order's patent unlawfulness reveals the gravity of the majority's error and underscores why equity supports universal injunctions as appropriate remedies in this kind of case. As every conceivable source of law confirms, birthright citizenship is the law of the land. The Citizenship Clause provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. U.S. Constitution Amendment 14, Section 1. That means what it says. Nestled in the 14th Amendment alongside the Equal Protection Clause, the Citizenship Clause does not discriminate on the basis of race, sex, ethnicity, religion, or importantly here, parentage. It refers instead to all persons born or naturalized in the United States. Besides birth, there is only one condition, that one be subject to the jurisdiction of the United States. Yet that condition, too, leaves no room for ambiguity. To be subject to the jurisdiction of the United States means simply to be bound to its authority and its laws. See Noah Webster, an American Dictionary of the English Language, 1865, defining jurisdictions as the power of governing or legislating or the power or right of exercising authority. Even if you're an illegal person, you're still subject to the jurisdiction of the laws. So they're trying to just say, well, remember that one little thing that was a little off to the side? Yeah, that says that we don't have to listen to the whole damn thing. That is not a nullifying clause. As the government would presumably concede, virtually everyone born in the United States and present in its territory is subject to its authority and its laws. After all, the jurisdiction of the nation within its own territory is necessarily exclusive and absolute, says Schooner Exchange v. McFadden. 7 Cranch 116-1812 Marshall CJ for the court. Once a citizen of another nation steps onto United States soil, she is, with narrow exception, amenable to the jurisdiction of the United States. That is why no plausible distinction with respect to the 14th Amendment's jurisdiction can be drawn between resident aliens whose entry into the U.S. was lawful and resident aliens whose entry was unlawful. Plyler v. Doe, 1982. Few constitutional questions can be answered by resort to the text of the Constitution alone, but this is one of them. The 14th Amendment guarantees birthright citizenship. It says what it means and it means what it says. It plainly says what it means and means what it says. Unsurprisingly, given the clarity of the Citizenship Clause's text, every other source of interpretation confirms this conclusion. Consider, first, its history. Long before the 14th Amendment, and indeed before the founding, the common law rule of jus soli, literally the right of the soil, governed English citizenship. That rule rendered a person's birthright determinative of her citizenship status. Thus, the children of aliens born in England generally were natural-born subjects and entitled to all the privileges of such. That comes from Blackstone, Commentaries on the Laws of England, the first edition, 1765. There's also some other H. Broom and G. Denham constitutional law described in Calvin's case, 1608, which established that everyone born within the dominions of the King of England is entitled to enjoy all the rights and liberties of an Englishman. That English common law rule carried over to the United States after the founding. Shortly after the Constitution's ratification, James Madison observed that it was an established maxim that birth is a criterion of allegiance, i.e. of citizenship. 1789. Birth, he explained, could convey citizenship in two ways, either through place, under the right of the soil principle, or through parentage, as for one born to United States citizens. So Ted Cruz is naturalized because they said that one of his parents was an American. He wasn't born here. So Ted Cruz doesn't give a shit about this country. He's trying to destroy this country, and he's trying to destroy this country for his own personal reasons. But in general, Madison explained, place is the most certain criterion, and it is what applies in the United States. So the fact that Ted Cruz was not born here, his father was tortured by the Batistas. So Ted Cruz could have been a badass. Ted Cruz could have been fucking awesome as shit. But instead of being like a Che Guevara, instead he's going to be the opposite. Madison explained, place is the most certain criterion, and it is what applies in the United States. Mere decades later, Justice Story wrote that nothing is better settled than the doctrine that the children even of aliens born in a country are subjects by birth. Ingles v. Trustees of Sailors Snug Harbor and City of New York, 1830. Well before the 14th Amendment, then, it was the undisputed law of the United States that every person born within the dominions and allegiance of the United States, whatever were the situation of his parents, is a natural-born citizen. Lynch v. Clark, 1844. Though the law was clear, the nation did not always live up to its promise. Infamously, this court departed from the birthright citizenship principle in Dred Scott, holding that the children of enslaved black Americans are not included and were not intended to be included under the word citizen in the Constitution. Following the Civil War, the Reconstruction Congress corrected that grave error. Section 1 of the Civil Rights Act of 1866 declared that all persons born in the United States and not subject to any foreign power would be citizens of the United States. The 14th Amendment's guarantee of birthright citizenship followed 2 years later. The lawmakers who ratified the 14th Amendment understood that it would extend citizenship to all children born here, regardless of parental citizenship. Indeed, some objected to its passage on those grounds, complaining that it would permanently extend citizenship to immigrants who invade state borders and settle as trespassers. Congressional Globe, 39th Congress, 1866. Proponents agreed, if not with the anti-immigrant sentiment, that the clause would extend citizenship to the children of immigrants. For example, Senator Conness of California, one of the amendment's lead supporters, confirmed on the floor that the children born here of Mongolian parents shall be declared by the Constitution of the United States to be entitled to civil rights and to equal protection before the law. We have declared that by law in the Civil Rights Act, he explained, and now it is proposed to incorporate the same provision in the fundamental instrument of the nation. Not one senator disagreed with this understanding of the clause. In the end, the Citizenship Clause was no legal innovation. J. Ho defining American birthright citizenship and original understanding of the 14th Amendment, 2006. Birthright citizenship is guaranteed by the 14th Amendment. That birthright is protected no less for children of undocumented persons than for descendants of Mayflower passengers. It simply restored the long-standing English common law doctrine of jus soli, abrogated. That's compared to the blood, jus soli, that's of the soil, versus jus san, I forget what blood is, abrogated by Dred Scott. The central purpose of the Citizenship Clause was, of course, to overrule Dred Scott. Following the ratification of the 14th Amendment, this court confirmed the amendment's plain meaning in U.S. v. Wong Kim Ark, 1898. At issue was the citizenship of Wong Kim Ark, a young California resident born in San Francisco to Chinese immigrant parents. When Wong returned to California from a trip to China, a customs collector denied him entry on the sole ground that he was not a citizen of the United States. This court held that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, as the president does today. The government in Wong Kim Ark rested its case on the clause's sole qualifier. Wong was not subject to the jurisdiction of the United States, the government claimed, because at birth his parents were aliens in the U.S. who were subjects of the Emperor of China, thus making Wong a subject of the Emperor of China as well. This court squarely rejected that attempt to limit the Citizenship Clause's reach. Instead, it held the subject to the jurisdiction qualifier excludes only children born of alien enemies in hostile occupation, children of diplomatic representatives of a foreign state, with the single additional exception of children of members of Indian tribes owing direct allegiance to their several tribes. That holding conclusively settled any remaining dispute over the Citizenship Clause's meaning. Since then, all three branches of government have unflinchingly adhered to it. So you only have three exceptions: Native Americans, children born of alien enemies in hostile occupation. So if we were trying to take over Bolivia, they were born there. And then children of diplomatic representatives of a foreign state. If some ambassador from France came over here and had children, those would be the only three exceptions. This court, for one, has repeatedly reaffirmed Wong Kim Ark's holding, notwithstanding legislative purporting to render Japanese persons ineligible for citizenship. We held in Morrison v. California, 1934, that a child with Japanese parents is a citizen of the United States if he is born within the United States. The court recognized the same rule even during World War II, when individuals of Japanese ancestry were subject to curfew and exclusion orders. See Hirabayashi v. U.S., 1943. So too has the court recognized that the child of parents unlawfully present in the United States is, of course, an American citizen by birth. U.S. ex rel. Hentopoulos v. Shaughnessy, 1957. The same is true of children whose parents gained admission into the United States by unlawful means. See INS v. Erico, 1966, INS v. Rios Pineda, 1985. Congress, for its part, has also reaffirmed the principles of birthright citizenship by enshrining it in a federal statute. Section 201 of the Nationality Act of 1940 provides that all those born in the U.S. and subject to the jurisdiction thereof shall be nationals and citizens of the U.S. at birth. 8 U.S. Section 1401A, see also Taggart v. Lorenzen, 2019, recognizing long-standing interpretive principle that if statutory term is obviously transplanted from another legal source, it brings the old soil with it. For at least the last century, the executive branch has adhered to the same principle. When Congress proposed to reaffirm birthright citizenship in the 1940 Nationality Act, cabinet officials described it as a statement of the common law rule which had been in the U.S. from the beginning of its existence. House Committee on Immigration and Naturalization. Indeed, the government concedes even now that the executive branch has recognized the vitality of birthright citizenship at least back to World War II, if not earlier. That explains, among other things, why the Social Security Administration and the Department of State have long accepted proof of one's birthplace as proof of citizenship. Some decades ago, the Office of Legal Counsel was asked to respond to a House bill that would have denied birthright citizenship to children born in the U.S. to parents who are not citizens or permanent resident aliens. That's a good point about Social Security. If you were born here, you got to prove that you were born here, and that gives you citizenship some other way. They're saying it's by parentage or whatever. So you got to prove that you were born here, and then you got to prove that your parents were born here, and then this is so stupid because it's almost like they're missing the forest through the trees. They're also very much against the Civil War amendments. Why are they against the 13th, 14th, and 15th Amendments to the U.S. Constitution? That's just saying that we are a free people. Black people that used to be slaves are now citizens, and to make sure that everybody understands this, by giving the black man citizenship, you're giving every white person, every white man, a citizenship as well. But if you're just a bunch of racist piles of shit, well, then you don't give a fuck about any of the laws. If you're just racist piles of shit, a bunch of fascist, fucking low-life, totalitarian racist, well, you're going to go after the brown-skinned people, and then meanwhile, all the meth and all the rapes and the murders and then all this other shit's going to go down. It's like we're focused on nonsense. And meanwhile, major felonies are going to be caused. So there's federal district courts in Maryland, Massachusetts, and Washington. Respondents include a group of pregnant women whose children will not be United States citizens under the terms of the Citizenship Order. 2 immigrants' rights organizations with thousands of members across the country who are likely to give birth to children who would also be denied citizenship under the order in 22 states, the District of Columbia, and the city of San Francisco. So they're saying 38 states might have this racist policy of just going after brown people, whether they were born here or not. That's where the line in the sand is. If you were born here, then you're an American. If you were not born here and you weren't naturalized, then you're not an American. That's the line in the sand. Respondents also sought a preliminary injunction barring enforcement of the Citizenship Order. Here they're pointing out that if you want to request a stay, then you have to prove that you will likely suffer irreparable harm. So what will be the harm that the Trump administration would suffer? They can't go around throwing Americans out of the country. That's the harm. But Your Honor, if we enforce the Constitution, then we can't just throw anybody out of the damn country that we feel like. That's a good thing. And then they're the ones doing the action. They're the ones that's, moving. And since the Trump administration with their ICE deportations are the one that's moving, the only irreparable harm is that they would, go home, maybe lose their jobs, maybe have a vacation, take a vacation, and don't go around throwing American citizens out of America. The majority's contrary position is self-refuting. Suppose an executive order barred women from receiving unemployment benefits or black citizens from voting. Is the government irreparably harmed and entitled to emergency relief by a district court order universally enjoining such policies? The majority apparently would say yes. This does suck for our civil liberties. As Americans, as freedom-loving Americans, our freedoms are under attack. If they come after birthright citizenship, what says that they won't come after the First, Second, Third, Fourth, and Fifth Amendments? Are there any freedoms that you Americans like? I like all my freedoms. Are there any freedoms that you Americans like? Because they're saying that if one person gets their freedoms taken away, then you have to sue. That's the only way you can get your freedoms back. If you don't sue, then they can't do a nationwide injunction. The majority's contrary position is self-refuting. It sure is. In Pierce v. Society of Sisters, too, this court affirmed a universal injunction of Oregon's compulsory public schooling law. So this was the right to educate your own children. Do you think you have a right to educate your own children? So the right to educate your own children came from a universal injunction of Oregon's compulsory public schooling law. You have a right to send your kid to private school, right? That's what Pierce v. Society of Sisters says. So they're coming after Pierce v. Society of Sisters. They're saying you don't have a right to educate your own kids if the state passes a law saying that your kids have to go to government schools, and even though you want to send them to private schools, well, you're fucked. You're fucked. You can't have a universal injunction. You have to sue personally. 2 private school owners challenged that law in a suit against the governor of Oregon and other state officials. The plaintiffs did not sue on behalf of a representative group or class. They sued for themselves, alleging that the law was an unconstitutional interference with their property rights. A 3-judge federal court awarded them a universal injunction. This court, in affirming that relief, twice described it as appropriate. The court understood that the injunction it affirmed would provide relief to non-parties, commenting that such relief was necessary because enforcing the act would have result not only in the destruction of appellees' primary schools, but would also destroy perhaps all other private primary schools for normal children within the state of Oregon. Cases like Lewis and Pierce were not outliers. Throughout the early 20th century, federal courts granted universal injunctions when a narrower remedy would have sufficed to redress the parties' injuries. West Virginia Board of Education versus Barnett, 1943. The universal injunctions of the citizenship order fit firmly within that tradition. The right to birthright citizenship is clear. The citizenship order is an illegal act, and without the preventive process of injunction, the right will be irreparably injured. Ark v. Oaks. Marbury v. Madison is quoted. The use of bills of peace was confined to limited circumstances. The universal injunctions in these cases, however, are more than appropriate. These injunctions, after all, protect newborns from the exceptional or irreparable harm associated with losing a foundational constitutional right and its immediate benefits. They thus honor the most basic value of our constitutional system. They keep the government within the bounds of law. They went back to Marbury v. Madison, 1803. So Sotomayor is going back to the founding. Marbury v. Madison, that's what established judicial review. The majority's contrary reasoning falls flat. The majority starts with the Judiciary Act of 1789, which gives federal courts jurisdiction over all suits in equity. And the majority's telling universal injunctions are inconsistent with equity jurisdiction because they are not sufficiently analogous to the relief exercised by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. So we're going back to English common law. In reaching that ahistorical result, the court claims that the English Chancellor's remedies were typically party-specific and emphasizes that party-specific principles have permeated this court's understanding of equity. The majority's argument stumbles out of the gate, as the majority must itself concede injunctions issued by English courts of equity were typically, but not always, party-specific. After all, bills of peace for centuries allowed English courts to adjudicate the rights of parties not before it and to award remedies intended to benefit entire affected communities. Taxpayer suits, too, could lead to a complete injunction of attacks, even when only a single plaintiff had filed suit. So that means these motherfuckers, because you guys are so against brown-skinned people, you're going to take away our First Amendment rights, our Second Amendment rights. You're going to take away our right to educate our own children. You're going to take away our right to not be taxed. If somebody says this tax is illegal and then that tax gets thrown out, then we're all safe from the tax. This is allowing the repression to continue. The majority seeks to distinguish bills of peace from universal injunctions by urging that the former, but not the latter, typically applied to small and cohesive groups and were representative in nature. Yet those distinctions without a difference. Those are distinctions without a difference. Equity courts had the flexibility to adapt their decrees to all the varieties of circumstances which may arise and adjudge them to all the peculiar rights of all the parties in interest. There is no equitable principle that caps the number of parties in interest. The damn chancery, the fucking court of chancery in England, that's what we're talking about. The court of chancery. Well, according to the court of chancery in England, we had a constitution for a goddamn reason. Why would we give a fuck what some monarch in goddamn England said about any goddamn thing? This is America. We got U.S. laws, we got legislative laws, we got case law. We got our own common law here. We don't need to go to old ancient England common law to fucking, the inherent jurisdiction of equity to interfere for the prevention of a multiplicity of suits, moreover, is what empowered common law courts to issue bills of peace. That's why early American courts understood taxpayer suits in which even a single taxpayer suing on his own accord and not on behalf of others could secure a total injunction to be a natural extension of a bill of peace. That bills of peace bear some resemblance to the modern-day Federal Rule of Civil Procedure 23 class actions does not mean they cannot also be a historical analog to the universal injunction. Contra 13, the Bill of Peace lives in modern form as the modern class action governed in federal court by Rule 23, not as the universal injunction. In the majority's view, Rule 23 class actions, but not universal injunctions, would be recognizable to an English chancellor because the limitations on class actions mirror those that apply to bills of peace. Rule 23 requires numerosity such that joinder is impracticable, common questions of law or fact, typicality, and representative parties who adequately protect the interest of the class. To the extent that English chancellors would care about the differences between Rule 23 and universal injunctions, the majority provides absolutely no reason to conclude that they would think the former permissible and not the latter. English chancellors, they would be okay with Rule 23, but they would hate the universal injunctions. Rule 23 of Federal Rules of Civil Procedure. They would hate universal injunctions, but not Rule 23 of Federal Rules of Procedure. Civil. Oh my God. The majority provides absolutely no reason to conclude that they would think that one is better than the other. English chancellors, whatever looks like a bill of peace to them. Rule 23, so you have to do class actions. They got to certify that the class is actually a class that is good enough to be a class. So it's like they're forcing people to go, as American citizens. So what we need to do now in order to combat this is, as American citizens, we need a group of strong Americans to oppose the damn thing. Good, strong American citizens would be able to oppose it because the class action would be those who are citizens of this country. By parentage, by blood, by soil, by what the fuck ever. So the class action would be American citizens standing up against birthright, the restriction of birthright citizenship. They are thus a common ancestor to both class actions and universal injunctions. In any event, nothing in Rule 23 purports to supplant or modify federal courts' equitable authority under the Judiciary Act to grant relief to non-parties, nor could it. The majority frets that universal injunctions, if permissible, will empower federal courts to create de facto class actions at will, thereby circumventing Rule 23's procedural protections. Those concerns, however, have not been borne out in reality. Rule 23 has coexisted with universal injunctions against the government for decades. Universal injunctions also cannot supplant the paradigm form of class actions which seek money damages. In all events, to the extent the majority's concern has any teeth, reviewing courts are already well equipped to safeguard Rule 23's procedural protections. If there is a genuine lack of clarity as to the lawfulness of challenged government's action, district courts may well abuse their discretion by reflexively issuing universal injunctions where a Rule 23 class action would be more appropriate. Ashcroft v. ACLU 2004, Standard of Review for Preliminary Injunctions is abuse of discretion. Indeed, equitable relief in the United States has evolved in one respect to protect rights and redress wrongs that even the majority does not question. Plaintiffs today may obtain plaintiff protective injunctions against government officials that block the enforcement of unconstitutional laws, relief exemplified by Ex parte Young, 1908. That remedy, which traces back to the equity practice of mid-19th century courts, finds no analog in the relief exercise in the English Court of Chancery. Ex parte Young, what was that? That was like the Attorney General filed the thing on his own accord, which could not enjoin the Crown or English officers. The English Court of Chancery could not enjoin the Crown or English officers. These motherfuckers are pushing for the presidency to be a monarch. Noting that in Young, the threatened conduct of the defendant would not have been an actionable wrong in common law, and that the principle in Young has been easily absorbed in suits challenging federal official action. Under the majority's rigid historical test, however, even plaintiff protective injunctions against patently unlawful government action should be impermissible. Such a result demonstrates the folly of treating equity as a closed system rather than one designed to adapt to new circumstances. It's a common expression that courts of equity delight to do justice and not by halves. Centuries ago, Chief Justice Marshall warned that if the legislators of the several states may, at will, annul the judgments of the courts of the U.S. and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery. U.S. v. Peters, 5 Cranch, 1809. The court should have heeded that warning today. Even the majority's view of the law cannot justify issuance of emergency relief to the government in these cases, for the majority leaves open whether these particular injunctions may pass muster under its ruling. Indeed, the lower courts issued the challenged injunctions consistent with an equitable principle that even the majority embraces. Courts may award an equitable remedy when it is necessary to provide complete relief to the plaintiffs. Califano v. Yamasaki, 1979, as the majority recounts, the equitable tradition has long embraced the rule that courts generally may administer complete relief between the parties. Quoting Kinney, Coastal Oil Company. Let's see here. The majority need not resort to hypotheticals, however, because the very injunctions in these cases were necessary to give respondents complete relief. Indeed, each district court found that a universal injunction was the only feasible option to redress fully respondents' injuries. Only a nationwide injunction will provide complete relief to the plaintiffs because the organizational plaintiffs have over 680,000 members who reside in all 50 U.S. states and several U.S. territories, and hundreds, even thousands of those members will give birth to children in the United States over the coming weeks and months. Alterations in original. A geographically limited injunction would be ineffective as it would not completely relieve the plaintiff states of the order's financial burdens. explaining that injunctive relief limited to the state plaintiffs would be inadequate because it would fail in providing complete relief to the state plaintiffs. Recognizing as much, the majority retreats to the view that even if a court can award complete relief, it should not do so reflexively. Complete relief is not a guarantee, it is a maximum a court can provide, suggesting courts err insofar as they treat complete relief as a mandate. Even so, the court never suggests that it's a fucking constitutional right. You should have a universal nationwide injunction for constitutional rights. You cannot fucking take away our goddamn rights as Americans. Even so, the court never suggests that the district courts in these cases should not have awarded relief to the parties nor completely remedied their alleged injuries, nor could it. The majority recognizes that in equity, the broader and deeper the remedy the plaintiff wants, the stronger the plaintiff's story needs to be. Here, respondents paired their respective request for complete relief with the strongest story possible. Without such relief, an executive order that violates the Constitution, federal law, Supreme Court precedent, history, and over a century of executive branch practice would infringe upon their constitutional rights or cause them to incur significant financial and administrative cost. Perhaps that is why the majority leaves open the possibility that the district courts in these cases could have granted at least respondent states a nationwide injunction consistent with the notion of complete relief. I think Sotomayor's dissent is going to stand the test of time if we're going to maintain that we're a constitutional republic. They're throwing the Constitution away. They're throwing the baby out with the bathwater. Such a system would also be incompatible with federal law. Some statutes, like those governing Medicaid and SNAP benefits, require states to give benefits only to applicants with a Social Security number to use those numbers for certain administrative purposes. So that means this is going to be food stamps. People on Medicaid and food stamps are going to be affected. So here it says that a problem with saying that Rule 23B2 class actions is better, or, is instead of using universal injunctions, you could just use Rule 23. It's saying that mechanism may provide some relief, but it's not a perfect substitute for a universal injunction. First, a named plaintiff must incur the higher cost of pursuing class relief, which will involve, at a minimum, overcoming the hurdle of class certification. So in order to do a class action lawsuit, you have to get it certified. You got to get that class certified. Demonstrating the prerequisites of numerosity, commonality, and typicality, and the adequacy of the named plaintiff to represent the class is difficult and time-consuming, and has been getting harder as a result of recent court decisions and federal legislation. She ends it off with this: the rule of law is not a given in this nation nor any other. It is a precept of our democracy that will endure only if those brave enough in every branch fight for its survival. Today, the court abdicates its vital role in that effort. With the stroke of a pen, the president has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way, because such complicity should know no place in our system of law. I dissent. I haven't read Justice Jackson's dissent, but maybe that'll be coming up next.